Okay.
Okay. All right.
Okay. You can make you can ask the students, who is this girl, who is this woman. I have used a photo. In the first lecture for my students of political philosophy, I explained what is a rule of law, what is a dictatorship, and I used a photo of Pinochet, but a young Pinochet.
With his sunglasses. And
Yeah,
I know the photo. Yeah.
And I say, who is this?
Yeah.
And they didn't know.
Yeah.
They didn't know who is this.
Yeah.
Okay, I introduce you.
Okay,
I make
sure.
a brief presentation. Hello and welcome to this special session of Cultural Pluralism and Right of Minorities workshop in Carlos III University in Madrid, Spain. Today we have a very special guest. Is Jeffrey Davis from the University of Maryland, Baltimore in the United States. And I would like to briefly present some of his biographical details. Jeffrey Davis is professor in the Political Science Department at the University of Maryland, Baltimore. He has taught human rights and related courses for 17 years. Well, 17 in the time of this CV, I imagine that now is 19 years. Winning several teaching awards, he is the author of Seeking Human Rights Justice in Latin America, Cambridge University Press 2014, and Justice Across Borders, The Struggle for Human Rights in U.S. Courts, Cambridge University Press 2008. Professor Davis has also published articles on national security, human rights law, human rights accountability, and the inter-American human rights system and the judicial decision-making. Before joining his current university, Professor Davis served as government attorney litigating constitutional and discrimination cases. I have to add that recently Professor Davis has been nominated, has been elected as member of the board of the RC26, IPSA RC26. Well, I am very pleased that he is in the board. I am the chair of the RC26, IPSA RC26, and we are going to work together. Today, the topic is constitutional injustice, racism, and the United States assault on human rights. This is clearly in the topic of this workshop on cultural pluralism and right of minorities. We are very pleased on having Professor Davis today with us, and we are looking forward hearing his speech. Thank you.
Thank you. So first of all, thank you all for coming, and thanks, Oscar, for inviting me and hosting me. So as you can probably tell from hearing a little bit about me, I came to this research through my research in Latin America, in human rights in Latin America. And in the human rights movement in Latin America, just like a lot of human rights movements around the world, you hear this phrase, no peace without justice. And so in meeting advocates and activists and survivors in Latin America, I began looking at my own country and thinking, well, why isn't that demand being made more loudly in the courts, being respected more loudly in the courts? No peace without justice. And so if we think about America, the United States' relationship with human rights, probably one of the images that comes to our mind right away is police violence against African Americans, specifically young African American men. When Officer Derek Chauvin knelt on George Floyd's neck for more than 9 minutes, killing him, the whole world saw the problem the United States has with human rights. Demonstrations swept the United States. They even reached Europe, including Madrid. Maybe people from this university were at this demonstration, Black Lives Matter demonstration in Madrid. We look at this phenomenon empirically, it's clear that police in the United States kill African Americans at a much greater rate than white Americans. And if you add Latinos, the numbers are shocking. But it's not just our relationship internally with human rights. It's how it's our external relationship with human rights too. And what I mean by that is how we act in the world with regard to our human rights policies. You don't have to look any further than our southern border for that. During the Trump administration, we were separating children from their mothers and fathers and placing them in cages. President Biden, that record hasn't improved that much. We're still not respecting the demands of the Refugee Convention and US law with how we treat people asking for asylum at our southern border. To say nothing of drone strikes in Afghanistan, torture at Abu Ghraib, or any of the other violations that have occurred over the last 20 years. Having said that, the United States also has its fingerprints on the idea of human rights. We're partially responsible for this notion of human rights. So how did we get to this point? How did we get to this point of having ignored human rights, having evicted human rights law from American law? So what I'm going to try to explain to you here, or try to argue to you here, is that we had three moments in our history, three crucial moments in our history, where we invented or helped invent or embraced human rights, only to reject them forcefully. The first was at our foundation, when the country was created. The second was after our Civil War in the late 1800s. And the third was after World War II. And so the presentation will show how US courts in all three of these eras have systematically extinguished human rights, in the last era, international human rights, from American law. Especially if we contrast those decisions with decisions in Europe, with phenomena in Europe. So as I go through this presentation, I'm going to be talking about decisions by American courts and American constitutional law. I try to avoid jargon or anything like that, but if I use a term or a concept that you're not familiar with, it's my fault. Please don't hesitate to raise your hand and interrupt me, and I'm happy to explain. So the idea of human rights was partially created, or at least nationalized, by the United States. It was based on this Enlightenment philosophy of John Locke and others who came up with the idea that all men are by their nature free. Thomas Paine expressed it as this notion of, we reject the idea that our rights come from a charter, a document handed down by some monarch. People have rights inherently. Our very first political act as a country, our Declaration of Independence, in the first section proclaims this and actually uses this idea as the primary justification for our separation with England. Right? Hold these truths to be self-evident. All men are created equal, endowed by their Creator with certain unalienable rights. Not only that, but we claim that governments are created for the sole purpose of protecting rights. That's their main function. Some of the men who created this, who helped found this new nation, were rather poetic about this idea of inherent human rights. Alexander Hamilton's quote here. And if you haven't seen the Broadway musical Hamilton, you have to see it because you haven't lived until you've seen this quote sung on a stage. So what happened? Slavery completely drowned out the idea of inalienable rights. Our Constitution has the protection of slavery in several sections. I have three of them listed here. The first is the new Constitution expressly allowed international slave trade until 1808. The second, the Constitution itself requires the states to return any slave who escapes from a slave state to a state where slavery is prohibited. And maybe the most important or the most damaging is the third here, which allowed states that had slavery, that legalized slavery, to count 3/5 of their slave population in calculating how many members of Congress they would have, thereby inflating the political power of the slave states. It was only a matter of time before the conflict between inalienable rights and slavery would reach our highest court. And it got there on board a Spanish ship called the Antelope. In December 1819, an American captain named John Smith took to the high seas from Baltimore Harbor, where I'm from, flying an American flag on a ship called the Columbia. But once he got out to sea, he lowered the flag and raised the revolutionary flag of Antigua, the Antiguan revolutionary flag. He renamed the flag the Araganta and went off attacking ships all along the African coast. He eventually took over a Spanish ship called the Antelope. And on board were about 300 African captives destined for the slave markets in the Americas. Smith commanded the ships back across the Atlantic to sell the Africans on the markets, but his own ship sank. So all he had was the Antelope when he reached the coast of the United States, where he was intercepted by an American Navy vessel and brought in for trial. After 1808, the United States had prohibited the international slave trade by any American. Smith was an American, so the American Navy was going to prosecute him for violating this law, thereby forcing the return of the Africans back to their home countries. But the Spanish owners decided to litigate this, and they claimed the ship wasn't American, it was Antiguan, and therefore there was no way that this was a violation of law. So it got all the way up to our US Supreme Court. And the Supreme Court had a choice. It could narrowly focus on the law passed by Congress prohibiting international slave trade by Americans, or it could embrace the idea, the inalienable right of liberty, the natural right, as this court decision said, for a person to be paid, compensated for a day's work. Unfortunately, they chose the former. John Marshall was one of our longest-serving Chief Justice. He was also a slave owner and was active on the slave trade, buying and selling slaves actively throughout his life, which means, of course, separating families in doing so. And he took a very positivist approach, saying unless there was a legal prohibition that outlawed slavery in treaty or statute, he could not rule that this ship had violated any law. It wasn't an American ship, therefore the law passed by Congress didn't apply. An American ship had no authority to seize African captives from a foreign ship on the high seas. A decision endorsing the slave trade. And notice what's happening here, using the language of the law, using the language of the Constitution in the absence of a prohibition of slavery to reject human rights. The nail in the coffin of the idea of inalienable rights, though, perhaps happened in a case called Prigg versus Pennsylvania. Here, it's a really tragic story of this woman, Margaret Morgan. Margaret Morgan was born in the 1800s, free, an African-American woman born free in the state of Maryland, which was a slave state. What had happened was her parents, when they reached the late 30s, their owner, John Ashmore, decided to release them, set them free, never dreaming that they would have another child. They did, So Margaret Morgan grew up free. She met a man from Pennsylvania, an African-American man who was free because Pennsylvania prohibited slavery, and they got married and moved to Pennsylvania and had children. When John Ashmore, the man who freed her parents, died, his children got a little greedy. They wanted as much money from the estate as possible, and so they hired a slave catcher, this guy named Prigg, to go up to Pennsylvania and bring Margaret Morgan and her children back. The law at the time required Prigg to get a warrant proving that this woman was an escaped slave, but he didn't do so. He just barged into their home in the middle of the night, dragged she and the 3 children back to Maryland. Pennsylvania authorities were angry. They filed charges against Prigg for violating their law, which prohibited by force or violence of taking away a person for the purposes of having that person enslaved. And so he was convicted and sentenced to prison. He appealed his conviction to the Supreme Court, and the Supreme Court had to consider whether you could convict someone for doing this. To those of us sitting here, it's clear, right? Of course, he kidnapped a free person, brought her back to another state against her will, and sold her back into slavery. Nevertheless, the Supreme Court struck down the conviction. And the photo you see here is an image of a poster in Boston. This was a common phenomenon in the United States at this time, because by this time international slave trade was prohibited. People would go into the northern states and kidnap African Americans and bring them south and sell them in the slave markets. There was a Hollywood movie, 12 Years a Slave, that portrayed that phenomenon. And so what the Supreme Court ruled was that Prigg had the right to recapture Morgan without any judicial process, and state personal liberty laws were unconstitutional. So instead of embracing an inherent right to liberty, or even the right to liberty expressed in the Constitution, the court focused on the fugitive slave clause I showed you at the beginning here, which gave states the right to demand for escaped slaves to be returned. And you can see here what's disturbing about this case is that the right that the court protects isn't the right of liberty, it's the right to own a slave, because that's the right that's expressed in the Constitution. It's even regarded as a fundamental right. This is Justice Story, who in his public speaking was very anti-slavery, but in his judicial ruling here, of course, was not. He had no hesitation in ruling this way. So inalienable rights were dead and buried at this point, which eventually this issue of slavery would cause the United States to erupt into civil war. And thankfully, the states that supported slavery lost that war. And again, the United States has another opportunity. Just like at its founding, it has this opportunity to base its legal system on liberty and equality. And it made an attempt to do so, the initial embrace. It passed 3 constitutional amendments. The 13th Amendment abolished slavery. The 15th Amendment prohibited states from discriminating in voting on the basis of race. And this one. This one tried to re-embrace inalienable rights. Here they refer to inalienable rights as privileges and immunities. Not only that, but they prohibited states from denying life, liberty, or property without due process, and mandated the equal protection of the laws. The whole point of this amendment was to correct those judicial decisions that I've been talking about that ruled that African Americans were unequal, that they didn't have rights. And yet within 3 decades of this constitutional amendment, the Supreme Court had eviscerated it. There are several cases. I'm just going to talk quickly about 2. The first one was U.S. versus Crookshank. This is just 10 years after the Civil War. African Americans were using their new political power to vote, to support candidates, And in the southern state of Louisiana, there was a very close race for governor. The candidate supported by the African American community looked like he was going to win. The candidate supported by the white was going to lose, and so encouraged white voters to organize. And they did. They organized into these mobs. Basically, some of them became terrorist mobs, the Ku Klux Klan being one of them, went around attacking African American communities, culminating in what this is an etching of the Colfax Massacre, where 100 men, women, and children were massacred by the Ku Klux Klan, punishing them for supporting this gubernatorial candidate. The state refused to prosecute these men for these murders, so the United States government did so. But when the case reached the Supreme Court said, no, you can't punish these people for doing this because the 14th Amendment only prohibits states from acting unequally, from discriminating, not private individuals. It didn't matter that the state was refusing to prosecute them, refusing to protect African Americans who were at risk of their lives. The court threw out this case. No one was ever punished for these murders. So a huge section of the 14th Amendment is weakened by that decision. And another famous case, Plessy versus Ferguson, here the Supreme Court endorsed our system of apartheid, of separating African Americans on public transportation, restaurants, public accommodations, basically ruling that this 14th Amendment only required political equality, not social equality. Notice the racist language in the court's decision, that the amendment can't eradicate distinction based on physical differences. If one race is inferior socially, the Constitution cannot put it on the same plane. So yet again, in the second phase, we had an opportunity with the 14th Amendment to establish a democracy based on liberty and equality, and it was rejected. The next historic phase was after World War II. At the beginning of the war in Europe, before the United States entered, President Roosevelt wanted to support England. And he wanted to get Americans behind the cause, and to do so, he came up with this idea of launching a struggle in favor of 4 freedoms. He gave a famous speech in the United States called the 4 Freedoms speech. And the 4 freedoms, some of them we were pretty familiar with, like the freedom of belief or conscience. But some of them were really interesting. The freedom from want was one of them. The freedom from fear was one of them. And the whole idea here was, hey, this is going to be a global war. Let's make it count for something. Let's make it count for human rights. And as the war drew close, some saw a real opportunity to say, the whole reason the war happened was because of a country's rejection of human dignity, rejection of rights. Let's fix this. Let's make this count. And so towards the end of the war, of course, the United States had forgotten this idea of 4 freedoms, and the other 2 of the big 3 had as well. But some of the delegates from the marginalized countries, less powerful countries, and some delegates from the United States even were really forceful in calling for this. And you see here India's delegates' articulate view of this. Hey, if we really want to make this peace last, we need to embrace fundamental human rights of everybody. W.E.B. Du Bois from the United States, and he'd been fighting for equality and rights in the United States, had this beautiful argument that if we're going to leave untouched the causes of the war, we can't expect to have peace. These delegates were partially successful. As you all know, the UN Charter does include a demand for human rights and equality. The demand is weak, though, right? It calls on nations to respect human rights and to work for human rights. And it also has strong provisions favoring national sovereignty. So once again, we have this opportunity, an opportunity in part helped along by Americans. You see here, after the war, Our President Truman referred to the Charter as a document dedicated to the achievement of human rights and fundamental freedoms. He nominated Eleanor Roosevelt to head the Human Rights Commission that would eventually draft the Universal Declaration of Human Rights, which was passed by the United Nations 48-0 in 1948. There was even an initial embrace of human rights in the United States. In this case, an American-born citizen of a Japanese alien family, a Japanese family that were not citizens, owned property. California prohibited Japanese Americans from owning property. It was a challenge to the Supreme Court, and the Supreme Court struck down the California law as it applied to citizens only. In the decision, though, 4 justices wrote separately to say that the UN Charter required this result. The Charter requires the United States to respect human rights and equality, using international human rights law to protect the rights of a racial minority in the United States. A case in California, brought by this time a non-citizen Japanese American, reached the California Court of Appeals, same law, prohibiting him from owning property. And this justice, Justice Wilson, struck down the California law, gave this man the right to own his property based on the Charter and the Universal Declaration of Human Rights. Justice Wilson recognized that something good has to come out of, as he says, the travail of World War II. And that something has to be the concept of respect for human rights. See, this is from his decision here, that this promise of human rights would be in vain unless the ideals of justice and equity are put into practice. They had to be put into practice, they had to be put into legal decisions, otherwise they'll be in vain. The response from conservatives in the United States was swift and fierce. From these 2 decisions, they recognized that if the Charter will have legal weight in courts, the African Americans living in the United States and other racial minorities could use the Charter to overturn segregation, voting restrictions, property owning restrictions, contractual restrictions that were placed on them just because of their race. The seed of this hesitation existed way back at the Charter when the Charter was being negotiated. Our main delegate, John Foster Dulles, was concerned about the human rights language in the Charter, and he asked one of his colleagues whether the non-discrimination provisions in the Charter might not create difficulties for the, quote, Negro problem in the South. But really, it was Senator John Bricker who led the charge against human rights, using the Charter to implement human rights in the United States. He proposed a constitutional amendment that would make treaties subservient to not only US federal law, but to state law. So if a treaty said you couldn't deny property rights to people because of their race, but California had a law saying you could, it was the California law that would take precedent. Jamie Merrifield has studied this period, and as he argues, Southern segregationists, nativist Republicans, and anti-communists joined forces to support the Bricker Amendment against the common threat of human rights. Keep in mind, these advocates weren't shy about why they were pushing for this amendment. See Bricker's quote here, offering to bury the so-called covenant on human rights so deep that no one holding public office will ever dare resurrect it. He referred to it as a covenant of human slavery. He specifically targeted the Sei Fuji case from California, saying, hey, imagine if the Supreme Court adopts that reasoning. The American Bar Association, which represents all American lawyers, The chair also supported the amendment, and the chair here said, clearly this warning of, hey, what if someone tells the black community that they can use this law? Imagine what will happen then. So clearly expressing the fear of how this will affect racial equality in the United States. The Eisenhower administration saw that the amendment was going to pass, so proposed a compromise. They promised they would not send any human rights treaties to the Senate for ratification. They withdrew the Genocide Convention from ratification, and still the amendment was just one vote away from passing. The next year, the California Supreme Court overturned the Fuji case. They did say Fuji to own property, but only based on US law, and instead ruled that the UN Charter does not supersede local laws. David Sloss, who's a treaty implementation expert in the United States, said the conservatives had successfully generated an atmosphere in which human rights treaties are seen as political poison. Even when we do ratify them, we include all these comments and exceptions to basically make them meaningless. And so the doctrines that emanated from these three periods of history remain in legal force today. And the result is a legal system that rejects the idea of human rights in favor of much narrow, judicially controlled constitutional rights. And those doctrines specifically result in police violence and the other phenomena we talked about at the beginning of this talk. I'm just going to give you a few little examples of this. George Floyd was obviously not the first African American who died at the hands of police because of choking. The New York Times did a study and found dozens, this has happened dozens of times in different cities across the United States. All of that could have been different had it not been from this case, LA versus Lions. Adolf Lyons was an African American man in Los Angeles. He was pulled over because one of his lights on his car was broken. The police ended up choking him nearly to death, despite the fact he was non-threatening and unarmed. He sued Los Angeles, but not just for damages. He was asking the court to issue an order prohibiting the Los Angeles Police Department from using the chokehold in cases where there wasn't a threat, where there wasn't a life-threatening situation. The lower courts agreed with it, absolutely. But when it got to the Supreme Court, they narrowed the issue to whether or not he was the right person to file this claim. The court uses our constitutional language to require you to have a specific personal stake in the outcome of a lawsuit that you file. What more personal a stake could you possibly have than nearly being choked to death? Well, they said that Lyons didn't have the right to sue because he couldn't show he was likely to be choked again. He has to show that he's immediately in danger of sustaining some direct injury. He can't show that he's immediately in danger of being choked to death again, so therefore he can't file this claim. Police shootings, also a clear problem with the United States with regard to human rights. And this case is just a good example of why that is and how hard it is to achieve accountability for this human rights violation in the United States. This case involved a young guy named Lehija who was, when police were trying to arrest him, he got in his car and sped off in a high-speed chase down the Texas highways. The police department had a procedure for this. They clear the traffic off of the road and then they plant metal strips along the road with spikes on them. And when the car goes over it, the tires blow and the car comes to a stop. Officer Mullinex had different ideas. Instead, she decided she was going to climb up on a bridge pull out her rifle and shoot the car as it came by at 75 miles an hour. She did, and needless to say, killed the driver, hit him with 6 different shots and killed him. So in just basic human rights jurisprudence, international human rights jurisprudence, the police would have to show that it was necessary to use lethal force at that moment. That would be the standard. But it's not in the United States. In the United States, we have a doctrine of qualified immunity, which means police and other government officials are immune from suit unless you can prove that the right that they're accused of violating was clearly established at the time. And clearly established doesn't mean that, oh, you have a right to life, and your right to life can't be taken away from you without a due process of law. It means that the actual factual situation has to be the same in a previous court decision that ruled it to be a violation of rights. Whoops. And so in this case, the court ruled that the officer was entitled to qualified immunity. Did a court clearly establish that the Fourth Amendment prohibited the officer's conduct in the situation she confronted? So notice this, the real problem with this doctrine is it creates circular and perpetual impunity, right? Because the court doesn't rule that this is a violation of rights, it's not clearly established, and therefore the next time it happens, that officer is also entitled to qualified immunity. The court knows this. If they wanted to change that, they could say, okay, this is a violation of rights. But it wasn't clearly established, so the officer gets immunity. But now we know it's a violation of rights, so the next officer knows that, hey, we can't do this anymore. But that's not how they do it. Just qualified immunity, case dismissed. These doctrines have also seeped into our efforts in counterterrorism. After the September 11th attacks, federal officials detained 700 people in a New York prison without any arrest, without any due process. They were held, and you can see the conditions. The Supreme Court found that they were held in deplorable conditions, lights on all the time. They were continually shackled, strip searched, slammed into the walls, twisted arms, broken bones, threatened with violence, humiliating sexual comments, and the rest was solely based on the fear of Arabs and Muslims at the time. This guy, the lead plaintiff, was actually Nepalese, and he was in New York, and he was taking pictures, and so he was arrested because that was deemed suspicious and because whoever arrested him thought he might be an Arab or a Muslim. These plaintiffs, some of them got together and with representation sued the United States and for violating their rights, the clearest rights possible, that you can't detain someone for a long time without any kind of judicial process. Nevertheless, the Supreme Court threw the case out. And the reason they give is that there is no law passed by our legislative branch that gives Americans the right to sue federal officials for violating their rights. Therefore, the court said, suing to enforce constitutional rights with damages lawsuits is now considered a disfavored judicial activity. Think about that. Enforcing your rights in federal court against federal officials is now considered a disfavored judicial activity. I'll just mention 2 more cases. DeShaney versus Winnebago County. This case is an all too common story where this little guy was being abused by his father. His mother and father were separated. The state officials got involved and intervened and knew all about it. Despite their mother's request, though, they kept on allowing the boy to go with his father, and eventually his father caused so much harm that the boy had a permanent disability. The mother sued, and here the court said, now, our rights come from the Constitution, and they're negative rights. They restrict government. They don't obligate the government to do anything to protect rights. So even though those state officials knew this little guy was in danger, they were not obligated to take any steps. And this precedent has resulted in incredible cases across the United States. The one that's the most alarming is a state-run ambulance picked up the victim of a gunshot wound. And even though the hospital was just 2 miles away, they didn't take him. And again, there the court said they're not obligated to do anything to protect his right to life. So there's no violation. This idea of rights being negative and only coming from the Constitution has a direct genealogy to the slavery cases. And then finally, I'll mention this case, Hernandez versus Mesa. In this case, Sergio Hernandez, a teenager living on the Mexican side of the Texas border, he and his buddies decided to run up and touch the US border fence and run back down into the culvert of the Rio Grande on the Mexican side. An American Border Patrol agent came up, tried to grab Sergio, so Sergio hid behind the pillar in the riverbed on the Mexican side of the border, and unfortunately the Border Patrol agent shot him and killed him. The family asked for extradition, but the United States refused to extradite Mesa into Mexico for prosecution, so they sued in US federal court. And the case is really a showcase in the doctrines of impunity in the United States. At first, they said that Mesa was entitled to qualified immunity because no court had ruled that killing someone across an international border was a violation of rights, so it's not clearly established. They then ruled that any government official has sovereign immunity to international human rights claims under a US statute called the Alien Tort Statute. When the Supreme Court got it, it used very similar reasoning to what we just saw in the Ziegler case, that there's no statute that gives this family the right to sue a federal official, so therefore the case is thrown out because enforcing your rights, even the right to life, is considered a disfavored judicial activity. Okay, so just to close in one or two sentences here, we can see a direct line from the race cases, both during slavery and after Reconstruction, after the Civil War, creating this idea that rights have to come from the Constitution and that their meaning is determined only by the Supreme Court of the United States. And as a result, these doctrines develop that have made it nearly impossible now to enforce rights in the United States. Okay, thank you.
Thank you. Very, very interesting. Some of the arguments are very appealing. It was a very history of the constitutional, of some of the constitutional cases on race in the United States, on race and other topics. Okay. Well, this is the workshop. This is the taller. No. Now we have an open time for your comments, for your questions. I have some questions, but I would like that if you have any comment or any question that you would like to ask, please, now is the moment. Go to the micro.
Buenas tardes, profesor. No sé hablar inglés, así que la pregunta la voy a hacer en español.
¿Está bien?
Ciertamente la Constitución de cualquier estado, pues, reconoce los derechos de las personas, ¿no?, de ese estado en particular. Sin embargo, creo que además de ser la norma máxima de ese estado, también está sujeta, aunque no lo querramos, a las interpretaciones que hacen los juzgados o los tribunales constitucionales. En el caso de México, por ejemplo, que yo soy de allá, en algunas ocasiones se presta a interpretaciones que, en vez de ser progresivas, son más bien restrictivas. Y en ese caso, pues la justicia constitucional queda muy entredicho. En el caso de Estados Unidos, no sé qué opina usted respecto de la interpretación que hace pues la Suprema Corte en casos pues bastante fuertes, como fue el caso de George Floyd, o incluso del niño, ¿no?, que usted menciona, que muere en la línea fronteriza entre México y Estados Unidos, aunque refiere, ¿no?, que pues ahora es considerado como una desventaja en la actividad judicial, ¿no? Pero yo quisiera ponerlo esto porque pues aún cuando para nosotros la justicia constitucional es un modelo que se reclama mucho, también tiene sus bemoles, ¿no? Y en algunas ocasiones pues nos quedamos con un sabor bastante amargo en la boca. Eso es todo.
Sí, tienes razón, es correcto y verdad. Lo que es importante es entender derechos humanos como algo internacional, algo de todo el mundo. Y eso no ocurre en países como los Estados Unidos, por muchas razones, pero uno de estos es que no somos parte de ningún corte regional o internacional. México sí, ¿no?, del Interamericano, el Corte Interamericano de Derechos Humanos. Y por eso no hay cultura de pensar en derechos humanos en Estados Unidos como algo del mundo. Es algo de nuestro constitucional. En Estados Unidos, abogados no hablan de derechos humanos, hablan de derechos constitucionales. Y eso es una de las causas de estos problemas. Y es bastante, hay un calle para solucionarlo, ¿no? Pensar en algo que viene de otro país no es algo extraño, algo de extranjeros, es algo americano, algo inventado por humanos como Alexander Hamilton y Eleanor Roosevelt. Es una idea americana también. Pues eso es mi respuesta. No, a ti gracias.
Ok. No, very well, very well.
Hola, buenas tardes, profesor. Excelente la exposición. Igual no sé hablar bien el inglés, entiendo lo que ha expuesto. Quisiera preguntarle por qué Estados Unidos no ratifica los tratados internacionales, como bien decía, del sistema interamericano, como por ejemplo el convenio 169 de la Organización Internacional del Trabajo, que tiene que ver con minorías, o pues lo que usted explica pues contrasta mucho con lo que se puede pensar de Estados Unidos, ¿no?, respecto a la política, la democracia y frente a los derechos humanos. ¿Qué está pasando? Estados Unidos, su actuar ante los otros países o el sistema interamericano es una forma de racismo igual, o siente que se puede ver obligado si ratifica los convenios, los tratados, por todos estos actos que usted ha explicado excelentemente aquí.
Okay. Voy a tratar de contestar. Sí, una de las razones más importantes, una de las causas más importantes de Estados Unidos no ratificando completamente estas treaties, tratados, es el racismo. Quieren controlar la dirección de su ley. Y si ratificar, hay ley extranjero que puede controlar qué va a ocurrir en Estados Unidos. Y por eso en este momento, después de la Guerra Mundial, tiene una población muy grande que está detrás del dedo de racismo, y si ratificar completamente estas leyes, no van a controlar esta población. Pero hay otra cosa también que tiene la relación con el racismo, es el concepto de American Exceptionalism. Pensamos que nuestro sistema es el mejor del mundo y es el mejor en garantizando derechos. La mayoría de americanos piensan que nuestro sistema es el mejor y tenemos más libertad de cada país en el mundo. Y eso ocurre, y por eso tenemos miedo de otros sistemas, otras leyes, otros tratados que van a entrar de afuera y limitar nuestros derechos. Y puedes ver esta cosa en las palabras de Bricker, ¿no? ¿Dónde está Bricker? Este concepto de no está aquí, pero no quiere aceptar leyes de extranjeros, de otros países, y hay una relación con comunismo aquí, ateísmo, eso es el concepto. Espero que he contestado bastante bien.
Okay, there is any intervention on the net?
Not so far.
No. Well, I would like to make some points, some remarks. The first one, it will be, okay, one of the approaches to the current situation of racism in United States or in Spain, I have studied the situation of Roma community in Spain. For example, the half of women in Spanish prisons are Roma, are Gypsy. And, well, not only me, but other authors have expressed the idea that criminal law is an indirect tool for racial minorities. But from your speech, I think you are more or less explicitly telling that law is a direct discrimination for racial minorities. If I understand well your cases, some of the cases that you are explaining is not an indirect discrimination, it's not a question of neutrality, it's a question that racial minorities are excluded, has been excluded. If I understand well your view. Because from your historical cases and some of the cases that you have explained, I think are the story of exclusion and a story of direct discrimination. Do you agree with this view, or do you want to comment something?
Yeah, so I think there has been intentional exclusion from every aspect of the process, from the legislating process to the adjudicating process as well. And I do endorse the work of some scholars who look at the law and look at judicial decisions as mechanisms of social control. And so if you have a fundamental element of American society is racial hierarchy, that is something that lawmakers and justices and judges are going to be tempted to defend. When they see after the Civil War, all of a sudden African Americans can own property and they can vote and everything is equal, that was a direct challenge to a society that they benefited from. And so there was an intentional exclusion then of them from those legal protections. Does that address your
No, it's
point?
okay.
Yeah.
It's
Yeah.
okay.
Yeah.
It's your conclusion. It's your
Yeah.
your approach. It's
Yeah.
it's. Yeah, I think it's a strong point, but you
Yeah.
can support
But
this view.
I mean, I can see an indirect effect as well, in the sense that in the United States, a minority is going to have far more encounters with the police, sometimes without any punishment. But we have in huge systems, any kind of job you want to get to, you'll be asked, have you ever been arrested? Right? And because African Americans and other minorities have these encounters with police, they have to answer yes, and therefore they're going to be denied employment. And so you have indirect effect of the racism as well, I think, which may be something similar to the Roma example.
Yeah,
as well,
yeah,
right?
of course. No, there is a exclusion and there is
Right.
direct discrimination for Roma people
Right.
in Spain and in Europe in general. It's a
Yeah.
marginalized minority in Europe. Okay, I have another point. Another point is more theoretical. It's about more or less theories of interpretation or theories of law. It's about the originalism and the living constitution, the originalism approach and the living constitution approach. Because I think what you explained is very interesting about the history of constitutionalism and the cases of race. But I think implicitly you are telling that in the interpretation, today's interpretation is constrained or is based in certain cases of the past. In a certain way, you are having a moderate originalist assumption, or otherwise, do you believe in the living constitution approach? Because your final conclusion that it's human rights today in America cannot be enforced. I think this comes from an originalist perspective. Maybe
No, it's really dangerous to sort of anchor my argument to originalism or natural law, or
Okay.
things like that, because what you end up doing then is you end up empowering judges and justices to anchor rights to what they meant in the 18th century. Or you empower them to interpret rights in and out of our law. I think an excellent example right now is the debate over abortion in the United States. Since 1973, people have understood that a woman's right to make decisions about that element of her life, of her body, is her fundamental right. But now all of a sudden we're wondering if that's going to be the case next year. And similarly with same-sex marriage in the United States, our Supreme Court recognized the right of same-sex couples to get married. But now there's new interpretations of the rights to religious freedom that are allowing private individuals to discriminate against people who are in same-sex relationships. For example, just last year, the Supreme Court allowed a Catholic charity that uses state money to run adoptions, to deny adoptions to same-sex couples. So I think the danger is depending too heavily on a court to define rights.
Well, at this point, I think it's very interesting for me because I would like to have the opportunity to ask then the question of accommodation for religious minorities. Is something that I have studied and I think is very important, very interesting. The different approach from the American approach of accommodationist and the European approach to this. you are in favor of accommodations, religious accommodations in workplace, or, for example, the typical cases of the Adventist of the Seventh Day, or the Muslim Bail, or these different, because there's how is the
Slippery slope. Yeah.
Slippery slope.
Yeah.
Is that the case of the gay cake?
Yes.
The cake that it's the baker that it's opposed for religious reasons to make a cake for a gay wedding.
Right.
Do you are in favor of religious accommodations, or depending of the case, or?
So here I think this gets to the idea of conceptualizing rights, defining rights. So for example, in the case that was decided last year, here the religious organization is conducting a public function, not a religious function, a public function. And they're using state money to do it. They're using public funds to do it. So in that situation, I think they have to obey the laws of equality and allow same-sex couples to adopt. On the other hand, a religious school, a Muslim school, in that situation, they're teaching Islam. That's a religious function, and they should have every right to teach whatever they believe their religion instructs them on that point, without interference from the state. So if the religious group or the religious person or whatever is doing a public function, then the rights of equality, the other human rights, can interfere. The cake shop is a really interesting example. He's in the public market. He's making his living by opening his doors to his community. He's benefiting by the city cleaning the streets and fixing the sidewalks, and now he's saying, I'm not going to serve you, and I'm not going to serve you. And to me, that gets very problematic.
Yeah, is interesting. Well,
Yeah.
I think you know the case of the original of the Adventists of the Seventh Day, that in Canada and in America has it is permitted the exception for the Saturday, and in Europe and in Spain is not permitted because it's a labor relation and there is no exceptions for religious reasons. In Europe in general and in Spain are reluctant, the courts are reluctant to make exceptions for these. Okay, well,
Yeah,
this
very
is something
interesting.
interesting.
Yeah.
Is something interesting?
Yeah.
Well, there is more. Okay, people are engaged.
¿Puedo hacer una pregunta?
Of course.
Okay. So, what I found quite shocking from your explanation is the idea that an American court can say that they have no duty to protect violations of rights when they are committed by individuals, not by the state. In the case of the 4-year-old, you commented like,
Yeah.
and this is not even, I assume that the right to life is on the American Constitution. This is not an imposition from international treaties. Like any other democratic constitution, it affirms the right to life from people. And is this could this be used as a valid precedent to say, for example, the state cannot enforce criminal law? Because for me, the implications of this, if you take them to their last consequences, are basically making the legal system useless. Someone could say, look, this person has killed my brother, but the state has no duty to protect the life of my brother against a violation from other individual. So how does the criminal system work in that case? And the sub-question to this is, if this is unsustainable from a logical perspective in a constitutional state that wants its legal system to work, but tribunals are using all these kinds of argumentative traps to escape from protecting human rights. Is this a problem of the law and the constitution, or is it just a problem of the racist culture ingrained in the people that are responsible for making those judicial decisions.
Okay, I'm going to answer your questions backwards and start with that one. It's a problem with the institutions, the law and the Constitution, and the way we put people in office. The United States is a minority-led country. Our Senate, has a tremendous amount of power, and it represents a vast minority of Americans. There are more people in one little town, one little city in California than 2 states, North Dakota and South Dakota combined. So it's a crazy system. And as a result of that, it's also very difficult to amend the Constitution. So as a result of that, it's very difficult for majorities to cause change. There's a tremendous amount of racism in the United States, of course, but I think there's a significant enough majority that embraces the idea of human rights that change could happen if it were institutionally more possible to do so. Criminal law, yes, so the idea of criminal law, most criminal law is carried out by states, and they're obligated to do so by their own state constitutions. Having said that, we have tremendous amounts of prosecutorial discretion. It's up to the prosecutor to decide whether to prosecute or not. In Spain and other democracies, there are private prosecutions that vary tremendously, but a private person can initiate a criminal case. Sometimes there's a gatekeeper very early, sometimes it's quite difficult, but in some democracies, and some in Latin America, they can bring the case pretty far along. That doesn't exist in the United States. And so as a result, with a case like this one or the Mesa case, the Sergio Hernandez versus Mesa, the family couldn't start a criminal case on their own, whereas they could have in another democracy. And so you do see the decisions that prosecutors make on who to prosecute and how strongly to prosecute having political motivations. But there's a case from Atlanta where a judge was killed and the prosecutor wanted the death penalty. And the defendant was willing to plead guilty and serve the rest of his life in jail, but the prosecutor refused, and so the result is it bankrupted the entire state criminal defense system defending this poor guy. So those kinds of decisions are very political because they're elected officials. Sure, there's a right to life in the Constitution, but not really. Our Fifth Amendment and our 14th Amendment talk about you can't have your life deprived without due process, but that just means that if there's process, you can have your life deprived. And if you look at Lions here, notice what they're talking about here when this guy is nearly killed is not this right to life, but the Fourth Amendment. Where is it? Anyway, the case is about the Fourth Amendment, which is unreasonable force when conducting an arrest. And so that's usually what they use, even when people are killed, that they use too much force when conducting an arrest. That's what they used in the Hernandez case. So yeah, so it's a very strange thing.
And now you want to ask something? Okay.
I think it's only a comment, but I prefer to speak Spanish because my English is not very good.
Okay.
I don't practice every day. Ok, soy venezolana, pero tengo una vida personal muy multicultural porque soy hija de padre francés, mamá venezolana, crecí entre Venezuela y Francia y he hecho distintos posgrados en diferentes países del mundo. La primera vez que viajé a Estados Unidos tenía 14 años y fue la primera vez que estuve confrontada con el racismo. Tomé el subway, el metro, y pasamos por las puertas del metro se abrieron en Brooklyn y una señora negra grande, muy fuerte, entró, yo estaba sentada y hizo así. She pushed me out. En un solo gesto, yo volé dentro del metro y me quedé. Y una persona que estaba conmigo en la próxima estación me dijo, hay que salir. yo no entendí en ese momento, creo que era muy joven y no estaba tan frente a la realidad. Y la explicación fue que era muy blanca, que me veían como una americana y que tal vez si hubiese hablado me hubiese visto latina y no americana. Y en ese momento, hoy en día o con los años, he pensado siempre, cuando se habla de racismo en Estados Unidos, se toma en cuenta, por supuesto, las comunidades mucho más febles, mucho más sensibles, como la comunidad negra, como la comunidad latina. En Francia aprendí a tener que cuidar el discurso y no decir cosas como comunidad negra, por ejemplo, porque es sensible. Porque el francés se acostumbra a cuidar el discurso, pero no a cambiar el pensamiento. Todo esto se lo digo porque yo creo que el problema o la situación de Estados Unidos, igual que la de Venezuela, México, en América Latina y muchas partes del mundo, es porque no cambiamos pensamientos, cambiamos discursos, pero hay que cambiar pensamientos. Y siento que en Estados Unidos, a través de la educación, se ha estado logrando formar una nueva generación de jóvenes mucho más involucrados en el día a día, en las situaciones reales del mundo, que podrían cambiar en un futuro la situación de los derechos humanos, tanto en Estados Unidos como en el mundo.
Sí, estoy completamente de acuerdo. La generación de mis estudiantes y de mis niños tienen ideas muy diferentes y están no solo hablando de estos temas, pero también trabajando, leyendo autores diferentes, trabajando con otras comunidades, viajando a otros barrios. Y es un esfuerzo muy importante, pero también muy grande en este momento. Y las manifestaciones después de George Floyd, se puede verlo, ¿no? En las manifestaciones como 60%, 70% blanco. Y viejos y todo, pero demasiado joven también.
Y con estas manifestaciones pienso que no me viene en español, en francés, oh my god, los redes sociales, los Facebook, todas las medias se han democratizado porque ahora llegan a mucha más gente y la gente toma su teléfono y filma. Y eso ha sido positivo, porque antes la información pertenecía a una cierta clase social que controlaba lo que se decía y controlaba lo que quería que la gente supiera. Hoy en día, a través de la democratización de la información, hemos cambiado también eso. Y creo que yo particularmente tengo esperanzas por la humanidad y pienso que las cosas van a cambiar para mejor, tanto en América Latina como en el mundo entero.
Yo también soy optimista, pero es mis estudiantes que me dan tan espero optimismos también. Sí. Gracias.
Muchas gracias por su conferencia.
Okay, I don't know if someone in the online want to say something. I have two more questions and we can finish. The first one is something that you said. I'm not really an expert on international law, but what you said about the international treaties subordinate to national law, that it's the case for United States.
What's your question?
No, you talk about that there is an amendment, there is a view that wants to this amendment. This is not enforced. This reminds me that what is called for our Latin American students the judgment of conventionality for the the priority, for example, in Mexico, there is a great discussion if the treaties has priority with the Constitution or the Constitution has priority to the treaties. This is something, and I think could be something similar, no? A debate, something similar. I'm not an expert on this topic. It's a topic of international law. And the other question is about what you said. Recently, I watched a film. I don't remember the name of the film, but it was an excellent movie about Guantanamo. The experience of someone who was imprisoned in Guantanamo. I don't know, 15 years without with an accusation that it was false. And okay, do you think this is a qualified immunity, or this is something stronger from the point of view of human rights or rule of law? What do you think is your interpretation of this?
So the Bricker Amendment here didn't pass. So the Constitution as it stands expressly says that treaties are the supreme law of the land along with the Constitution. So it doesn't settle that debate that you're talking about which one takes precedent. The Supreme Court has said that the Constitution takes precedent. But after the Bricker Amendment, courts adopted his philosophy and basically ruled that treaties are not enforceable unless Congress passes a law saying how they are enforceable. And so there's a famous a case where the United States has an extradition treaty with Mexico, but they can't wait long enough for it to happen, so they actually hire private mercenaries to go into Mexico, kidnap the person and bringing them back, violating the extradition treaty, and the court says that it doesn't matter, we can still prosecute them. So yeah, so that's our enforcement of treaties is very, very weak now in the United States. It's sort of like the American tourist who travels to Madrid and wants to eat at McDonald's the whole time. That's our relationship with international law. As far as your other question about Guantanamo, I think Guantanamo's violation of human rights are multi-layered, but they're certainly beginning with the idea that the detainees there have no right to go to a court and enforce their human rights law. They have to operate inside the box of constitutional law. And the first hurdle they had to overcome was they're in Cuba, and the Constitution only applies in the United States. Which is a doctrine that came when we used to have colonies in Philippines and things like that. And so that took 10 years for them to, not quite 10 years, eight or 9 years for them to get the Supreme Court to say, oh yeah, the Constitution applies there. And so now, little by little, trying to get more and more judicial oversight there, but it's impossible. There's a case from Guantanamo before the Supreme Court right now where Abu Zubaydah wants to provide evidence of his torture in his criminal trial, because no information gained through torture should be allowed in the trial. But the U.S. government says, no, we're not going to tell you that information, it's secret. And so the Supreme Court is considering whether that would violate his right to a fair trial. So it's very, very difficult, and largely because of this phenomenon that we're talking about here.
Okay, I think it has been an excellent session. I would like to really thank Jeffrey Davis for his words and for his magnificent speech. Thank you very much for your participation, and see you in the next session of the workshop, Cultural Pluralism and Rights of Minorities. Thank you, everyone. Thank you.
Y lo siento por mis errores en mi español.